Hi, everyone. I'm back to discuss the May 30th, 2025 Supreme Court order in the case called Noem versus Doe, case number 24A1079. In this episode, I'll discuss the main issues, highlight the decision, including Justice Jackson's dissent, and offer a couple quick takeaways. Please note that this episode is read by an automated voice. The central issue in this case is whether the Secretary of Homeland Security lawfully terminated the CHNV parole program and the existing parole status of approximately 500,000 individuals through a single Federal Register notice, or if this en masse termination exceeded the Secretary's authority and violated statutory requirements for case-by-case assessment and proper legal reasoning. Here's the backstory. Nearly 500,000 Cuban, Haitian, Nicaraguan, and Venezuelan non-citizens presently live in the United States by virtue of temporary permission granted to them by the Department of Homeland Security, DHS. Under the CHNV program, individuals from these conflict-ridden countries receive parole status for up to 2 years, which allows them to live in the United States and, in some cases, work here lawfully. Parole is discretionary by statute. DHS awards parole status through a competitive and detailed application process that involves a rigorous, individualized assessment of the applicant's circumstances. On January 20th, 2025, the President issued an executive order that instructed the DHS Secretary to terminate all categorical parole programs, including CHNV. DHS thereafter announced the termination of the lawful status of all CHNV parolees in one fell swoop through a single Federal Register notice. Respondents, who had already filed a putative class action in the District of Massachusetts, amended their complaint to challenge the DHS notice. They alleged, as relevant, that the Secretary had acted arbitrarily and capriciously, contrary to law, and in excess of her legal authority by prematurely terminating their parole. The district court temporarily stayed DHS's notice because, generally speaking, the district court determined the federal statute requires that parole terminations occur on a case-by-case basis, rather than en masse. The First Circuit declined to disturb that decision pending appeal, but invited any party intending to seek expedited briefing of the merits to file an appropriate motion as soon as practicable. Rebuffing the First Circuit's invitation, the government filed a stay application with the Supreme Court. The question presented before the Supreme Court is whether the Supreme Court should stay the April 15th, 2025 order entered by the United States District Court for the District of Massachusetts, pending appeal to the U.S. Court of Appeals for the First Circuit and any further proceedings in this court. The government asserted broad, largely unreviewable discretion to revoke parole categorically based on policy changes and national interest, arguing the courts have limited jurisdiction. Conversely, the respondents contended that such a mass revocation is subject to judicial review, was arbitrary and capricious, procedurally flawed, based on legal errors, particularly concerning expedited removal eligibility, and would inflict devastating, irreparable harm on individuals who relied on their granted parole status. The Supreme Court granted the application and stayed the district court order. This means that DHS can terminate the lawful status of all CHNV parolees and proceed to remove them pursuant to law. The justices did not sign the order. Justice Jackson filed a dissent from the grant of the stay application and was joined by Justice Sotomayor. Here's Justice Jackson's dissent. When this court evaluates whether or not to stay a lower court's order, the factors we apply are well established. The applicant must show a fair prospect that we will grant certiorari and reverse, that the merits favor them, that irreparable harm will befall them should we deny the stay, and in close cases, that the equities and public interest are on their side. In any given case, Each of these considerations bears on the appropriateness of the requested intervention and is a prerequisite to obtaining relief. The court has plainly botched this assessment today. It requires next to nothing from the government with respect to irreparable harm, and it undervalues the devastating consequences of allowing the government to precipitously upend the lives and livelihoods of nearly 500,000 non-citizens while their legal claims are pending. Even if the government is likely to win on the merits, in our legal system, success takes time, and the stay standards require more than anticipated victory. I would have denied the government's application because its harm-related showing is patently insufficient. The balance of the equities also weighs heavily in respondents' favor. While it is apparent that the government seeks a stay to enable it to inflict maximum pre-decision damage, court-ordered stays exist to minimize, not maximize, harm to litigating parties. The decision whether to stay a lower court's order does not reflect a back-of-the-napkin assessment of which party has the better legal argument. Rather, the dilemma that stays historically addressed was what to do when there is insufficient time to resolve the merits and irreparable harm may result from delay. The central question, then, is whether the applicant can be made to wait until the conclusion of the litigation to vindicate their purported legal rights, or whether irreparable harm will befall the applicant in the interim, such that the court must act early to stave off that damage for equity's sake. Consistent with this principle, this court has long understood that the authority to grant stays is only justified by the need to prevent irreparable injury to the parties or to the public pending review. Hence, even if an applicant is likely to succeed on the merits of their legal claims, we also ask whether they have demonstrated irreparable harm. In addition, the successful stay applicant must show that the harm they would face from not receiving a stay is greater than the harm that the opposing party would face if a stay were granted, as well as that the requested stay is in the public interest. Whereas here, the government is a party, the balance of the equities and public interest factors merge. Notably, if the Court of Appeals has already denied the request for a stay, the applicant bears an especially heavy burden to receive a stay from this court. We have long viewed such an intervention as extraordinary. Consequently, we have deemed the irreparable harm showing indispensable. Indeed, an applicant's likelihood of success on the merits need not even be considered. If the applicant fails to show irreparable injury from the denial of the stay, the bottom line is this: our decision to issue a stay or not involves more, much more, than merely forecasting the eventual victor. After all, the underlying litigation is designed for and dedicated to determining that. What stays are about, at their core, is an equitable assessment of who will be harmed and to what extent during the litigation process, with the ultimate goal of reducing the real-world consequences of the unavoidable pending case-related delay. In this case, the government has plainly failed to satisfy its burden of demonstrating irreparable harm. DHS contends that the district court's order prevents it from exercising its prerogatives with respect to immigration and foreign policy as a general matter. Application for Stay 24. But it does not establish an urgent need to effectuate blanket CHNV parole terminations now before the courts can determine whether that en masse agency action is lawful. For instance, the agency does not identify any specific national security threat or foreign policy problem that will result from respecting extant grants of CHNV parole while this case is pending. Moreover, as the government admits, DHS retains the ability to terminate CHNV parole on a case-by-case basis should such a particular need arise, consistent with the district court's order. The lack of any concrete or irreparable injury to the government from having to wait to claim its assumed victory is especially salient in light of the First Circuit's willingness to expedite its consideration of the merits of this matter, an invitation that the government eschewed for more than 3 weeks. The government's failure to show irreparable harm should end the inquiry. Its stay application fails on that basis alone. But an evaluation of the balance of the equities factor provides an additional reason why our intervention staying the district court's order is not appropriate. Respondents have shown that tangible, imminent, and significant harm is likely to befall them if this court grants the application and issues a stay. A stay would immediately effectuate the en masse truncation of all parole grants for approximately 500,000 current CHNV parole beneficiaries in the United States. Many parole recipients arrived here at the invitation of the U.S. government because their home countries were afflicted by strife or they were otherwise subject to unsafe living or working conditions. Parolees have sponsors here and, in many cases, have integrated into American neighborhoods and communities in the hopes of eventually securing long-term legal status, e.g., asylum. No one disputes that social and economic chaos will ensue if that many non-citizen parolees are suddenly and summarily remanded. Respondents now face two unbearable options. On the one hand, they could elect to leave the United States and thereby confront dangers in their native countries, experience destructive family separation, and possibly forfeit any opportunity to obtain a remedy based on their claims, as the district court found. On the other, they could remain in the United States after parole termination and risk imminent removal at the hands of government agents, along with its serious attendant consequences. Either choice creates significant problems for respondents that far exceed any harm to the government, should this court decline the stay request. Both options might also deprive this court of jurisdiction to decide respondents' pending claims. At a minimum, granting the stay would facilitate needless human suffering before the courts have reached a final judgment regarding the legal arguments at issue, while denying the government's application would not have anything close to that kind of practical impact. With the stakes as high as they are in this case, measured in terms of real harm to real people, one might reasonably expect the government to step up to equity scale with a mountain of harm-related arguments bolstered by evidence. The government bears the burden of showing why it, or the public, will be irreparably injured should it be prevented from exercising its policy preferences now, i.e., while the lawfulness of this agency action is being litigated, this court has repeatedly denied similar stay requests from federal agencies in recent years, unmoved by the bald contention that the government is irreparably harmed whenever its substantial interest in carrying out the president's policies is burdened. The government says no more than that today, yet somehow the court has now apparently determined that the equity balance weighs in the government's favor, and I suppose that it is in the public's interest to have the lives of 500,000 migrants unravel all around us before the courts decide their legal claims. Even assuming a likelihood that the law permits the government to terminate parole grants in this fashion, I would let the courts decide that highly consequential legal issue first, consistent with standard stay practices and especially the necessary harm-centered focus. Instead, the court allows the government to do what it wants to do regardless, rendering constraints of law irrelevant and unleashing devastation in the process. Here's a couple quick takeaways from the emergency docket decision. I'm not keeping a tally, but these days, immigration issues seem to dominate the court's emergency docket decisions. As is often the case with these types of cases, the majority provided no reasons for their decision. That leaves us wondering what factors were at play. Maybe, as Justice Jackson implied, the court placed heavy emphasis on its belief that the government will win in the long run. It's also possible the court sided with the government and felt the people challenging the decision overstated their harm, especially since their own brief admitted they could still fight their removal. Side note, if this is the case, I'm sure the court wants the government to read its other emergency docket decisions and to afford due process to the respondents. And of course, the court's ongoing concerns about nationwide injunctions might have been a factor too. Also notable here is that Justice Kagan, who often sides with Justices Sotomayor and Jackson in the dissent in these kinds of cases, did not join the dissent this time. Time will tell how things shake out. Thanks for joining. Talk to you again soon.